and welcome everybody. We are glad to see you today for Professor Cecilia Balliet's presentation of her book on the construction of the customary law of peace, Latin America and the Inter-American Court of Human Rights. So we will first have a presentation by Cecilia of her book, and then we have another speaker, Jorge Contes, who will offer a few comments on her presentation and the book in itself. So I will start by presenting both of them very quickly so that we have more time for the discussion afterwards. So Cecilia Balliet, I'm not sure if I'm pronouncing this right, is Professor Dr. Juris and Director of the Master's Program in International Law, as well as co-director of the Research Group on Human Rights in Conflict, Peace and Security at the Faculty of Law at the University of Oslo. She was born in Buenos Aires in Argentina and has served as consultant to national and international organizations. Her research has been the basis for the creation of guidelines in various institutions. And she also created the courses Refugee and Asylum Law and the Right to Peace, and is in charge of the master's level course on public international law at the law faculty also in Oslo. And obviously, I could say much more about her, but I will now turn to Jorge. So Jorge is a scholar of international human rights and comparative constitutional law. He's focusing on the judicialization of international law and on the interaction between domestic constitutional actors and international human rights regimes, in particular the Inter-American human rights system. His work has appeared in the American Journal of International Law, the Harvard International Law Journal, and the International Journal of Constitutional Law, as well as the Yale Journal of International Law, among others. And he's the senior co-chair of the Latin America Interest Group of the American Society of International Law, which is co-hosting the event today together with Rutgers University. And he will offer his comments on Cecilia's book after her presentation. So with this, I will hand over the microphone to Cecilia. We are looking forward to hearing from you. Thank you very much for joining us today.
Thank you very much. I especially give my warm thanks to Jorge Contes for giving me the opportunity to present this book that was the result of a most auspicious sabbatical year at the University for Peace in Costa Rica. So my interest in this topic resulted from the emergence of new normative iterations of peace at the international level. Specifically, we have a UN Declaration on the Right to Peace, and this was voted in favor of by absolutely all the Latin American countries, and it was adopted by the General Assembly. We also have peace being actually a UN Sustainable Development Goal number 16. And so I was inspired by these to explore the idea of peace as being a type of Grundnorm, which has received universal recognition, both as an end and as a means of legal systems, because one can only achieve peace through pacific means of dispute resolution, as set forth in the UN Charter and other international instruments. So as a Grundnorm, states should ensure that their laws, their practices, and their policies harmonize with the aim of peace, interpreting it always with the human rights instruments to form a type of pro homine peace. And this can have pluralistic manifestations. So if we go back to understand how peace evolves normatively, it commences with the notion of negative peace, which is the absence of violence, the prohibition on the unlawful use of force. And Kelsen actually considered negative peace to be the only type of peace that could be considered legal, because it would then incur state responsibility and international criminal responsibility in the violation of the norms on the use of force. And of course, we have Kant's perception of humanity reaching a type of a stage of civilization where republics renounce the use of force and pursue perpetual peace, resolving their conflicts in a nonviolent manner. But a Norwegian scholar, Johan Galtung, came along and said that actually negative peace is only part of the picture, that you actually, when you look at societies and violence and divisions, that we need to expand the notion of peace to incorporate what he called positive peace. And positive peace would be the pursuit of the elimination of structural violence through equality, non-discrimination, cooperation, social justice. And this was criticized by Kenneth Boulding because Kenneth Boulding said that this is a metaphor, that positive peace can't be implemented in a practical way. So when I went to Costa Rica and I went to the court and I spoke to all the lawyers at the court, and they were very clear that they didn't just want me to look at the case law and the constitutions. They said that the context of Latin America was very important to describe, that they wanted me to describe the challenges that were happening, that they were grappling with in trying to respond to. So Latin America has always been characterized by enjoying this period known as the long peace, which refers to its restraint on the use of force between states. But my book seeks to explain that even though Latin America has been largely successful in adhering to negative peace, the challenge of peace right now within the region is precisely due to its failure to implement positive peace strategies to correct the inequality and discrimination that is at the formation of the internal violence that we see today by criminal gangs and paramilitary groups, the extent of corruption and the trend towards elected authoritarianism, the problems relating to economic downturn and migration. So it's estimated that the richest 10% of the population control 54% of the national income. And this is in part due to the hierarchical structures that are linked to the commodity dependence economies of fossil fuels, mining, and agriculture. And this type of dependence then exploits and marginalizes racial minorities, indigenous people, women, and youth. And so we have the region being marked by persistent cycles of protests and social unrest met by state repression, upholding an oppressive state of what Mark Leonard would call unpeace. And moreover, we're seeing a significant increase in attacks on human rights defenders, including those who protest corruption and impunity or calling for environmental protection and social justice. So the current war in the Ukraine and its long-reaching negative economic consequences has only underscored the imperative of peace, and it creates a perfect parallel for one of the focal points in the book, which is recalling the Inter-American Conference on the Maintenance of Peace that was held in Buenos Aires in 1936. And this was organized by Carlos Saavedra Lamas, the Nobel Peace Prize winner, who had helped bring about peace after the terrible Chaco War between Paraguay, which was supported by the Shell Oil Company, and Bolivia, supported by the Standard Oil. And in this terrible war, both countries lost between 3% and 2% of their populations. So President Franklin Roosevelt invited the heads of state of the Americas to participate in the first joint presidential radio broadcast in the region. They wanted to promote mechanisms for regional peace and to avoid the absolute catastrophe of war that was plaguing Europe at the time, because Italy had just occupied Ethiopia. And so Roosevelt gives a speech in which he's talking about the aim of creating a permanent peace in the region. And they drafted a declaration of principles for inter-American solidarity and cooperation, which set forth the prescription of territorial conquest, the condemnation of intervention in the internal and external affairs of another nation, the illegality of the forcible collection of pecuniary debts, and this is then incorporating the Drago Doctrine, as well as pointing to dispute resolution via conciliation, arbitration, or international justice. And this is then later followed up by the Declaration of Lima, the Rio Treaty, and the Pact of Bogota, which recognized the compulsory jurisdiction of the ICJ. Now, it's notable that the ICJ is addressing various territorial disputes relating to oil and natural gas exploration at sea, as well as water rights. And states in the region are showing some resistance to this form of dispute resolution. And this indicates actually that we may be seeing a risk of militarization at the maritime borders and potential violation at one point of the long peace. So for example, Guyana and Venezuela are competing for this Starbrook block, and Venezuela does not recognize the jurisdiction of the ICJ in the case. Similarly, the Treaty of Bogota was ironically denounced by Colombia, which said that it preferred to negotiate with Nicaragua after the ICJ ruled that Colombia had violated Nicaragua's sovereign rights and jurisdiction in the maritime zone. And one, of course, may also consider that both Argentina and the UK are at present celebrating the 40th anniversary of the Malvinas Falklands War, which remains contentious as Argentina seeks recovery and the UK will not negotiate. So we can't take the long peace for granted, because what's at stake here is also, you see, the Sea Lion oil field that is of interest to both countries. Tensions will be rising for pursuit of these offshore natural resources. But nevertheless, the OAS Charter created a wonderful architectural foundation for the enjoyment of both negative and positive peace, because it condemns wars of aggression, it prohibits intervention, and it calls for peaceful procedures for dispute resolution. And it also calls for social justice and social security, listing them precisely as being bases of peace. So it's calling for positive peace in addition to peace education. So the next part of the book, then, it goes to looking at creating a typology of how is peace normatively identified in Latin American constitutions. And I found that they're very pluralistic. You have a true tapestry of variations that take either negative or positive peace orientations that actually are quite reflective of the historical context of the nation, but also provide evidence of the flexibility of peace. Now, I was surprised because the majority of the constitutions are what you would call internally oriented statist liberal expressions of peace as a condition for enjoyment of a right, your right to peaceful association, to peaceful speech, to peaceful assembly, to peaceful petition, and in Mexico, peaceful writing, actually. And this reflects the concern during the consolidation of independence in the region to retain social order and control. And this is a concern that exists and persists to this present time. Absolutely every one of the Latin American countries experienced protests the year that I was writing the book, in 2019. So the Inter-American Court of Human Rights responded to repressive tactics by the state through provisional orders, which address extreme, grave, and urgent situations that require prevention of irreparable harm, meaning the right to life or physical integrity of the human rights defenders, the indigenous community representatives, the journalists, and even the judges, and as well as addressing arbitrary detention of political opponents. So the court then, when they issue the provisional orders, this is their first level of attempting to break the cycle of exclusion, protest, and repression that is the consequence of the region's failure to implement positive peace. Another group of constitutions refers to externally oriented negative peace, calling for peaceful coexistence, the obligation to pursue peaceful settlement of disputes. And here you even see a free passage. The Panama Canal literally is offered as a form of peace. And these relate also to a whole series of constitutions that renounce war or prohibit nuclear weapons or condemn wars of aggression. So we've seen the emergence of sub-regional peace zones, nuclear-free zones, and these institutions are under pressure because we're seeing states transgressing maritime territories, either with nuclear power subs that are armed with conventional weapons or with literally nuclear weapons. But we do have the Treaty on the Prohibition of Nuclear Weapons, and Bolivia, Mexico, the Central American states have ratified this, but interestingly enough, Brazil and Argentina have not. So this is another point of tension in relation to our long peace that we have to pay attention to. Now, in terms of recognition of peace as a justiciable right or duty, I was so disappointed because there are very few cases. It was Bolivia and Colombia, Haiti, Ecuador, Venezuela, and Guatemala. And the country that had the greatest level of jurisprudence was, of course, Colombia, because of its 1991 peace constitution. And there you see peace is from the preamble to Articles 2, 3, and 22. It's both a right and a duty of the state and society. And the judges are very good at explaining the scope of peace, both as a substantive aim and also as a procedure, demonstrating very clearly that peace can be justiciable. But the most exciting case was from Costa Rica. This is the country without an army. And so they had a law student who was very alert and noticed that the executive had put on its website its support for the US war in Iraq. And the law student said, this is illegal. And he brought the case, and the court agreed very, very strongly and ordered the executive to take down the allegiance from the website. But the most flexible part of the normative iterations of peace are the ones that actually connect to what we call programmatic approaches to human rights, meaning not through the courts, but using other agencies. And so I saw examples of jurisdictions like Peru that has an actual law that requires schools to teach cooperation, to teach mutual respect, to teach gender justice. And UNESCO is promoting many programs with promoting peace activities among the youth. And even the picture of the women on the right, this is in the Dominican Republic, that technically is not in the Constitution, but they have widespread programs that are trying to promote peaceful dialogue within the area. And many of the jurisdictions also have systems of alternative dispute resolution for labor conflicts. And these institutions need more financing, and they need more support, because we also know that Latin America has the highest levels of violence against workers in the world. So it's no surprise that the Inter-American Court recognized standing for trade unions themselves to present claims. So the section on the constitutions is followed by a presentation of the views of former and current judges of the Inter-American Court of Human Rights, all of whom absolutely agree that peace is an aim or a value of the international system, but they range in their articulation of the scope of peace. So just like the constitutions are pluralistic, the judges also present a variety of views. So you'll see holistic perspectives like Judge Gross Ispiel, where he's voicing that this is a right and duty of states, individuals, international organizations, that he considers the jus cogens as a corollary to the prohibition of the use of force, and that he sees it as an individual and collective right. And this is very much in keeping with the thinking around third generation rights, peace, development, the right to environmental health, and the right to solidarity. They're all intended to be applicable in a broader manner than the traditional first generation rights. And Judge Cansado Trindade, he actually participated in many of the meetings with UNESCO and tried to flesh out how the right to peace could be characterized. He linked it a lot to the collective cases of vulnerable groups like indigenous people, displaced people, people who have been subjected to massacres, and people also who are afraid of being subjected to the use of nuclear weapons. So the review of these positions were linked to the fact that I found a specific reference to the right to peace in the Ober Dictum in one advisory opinion on environmental health, where the court actually says that when people are being displaced because of environmental damage, they will have a higher risk of having conflicts with other communities, and therefore that would be a violation of the right to peace. So this is as far as we have come in terms of incorporating it in a very literal manner. But the court then is divided on the issue of justiciability of second and third generation rights. And this is relevant to peace. So you can imagine my shock and horror when I read the American Convention and the American Declaration, and I found that neither one of them made explicit mention of the word peace. This was very upsetting. But when I look back at recognizing that positive peace is grounded in equal protection and non-discrimination, of course, that is contained in Articles 1 and 24, or you can do a reference of indirect justiciability via Article 29. And you have the notion of peace education appearing in the Protocol of San Salvador, and thus incorporating a potential justiciability there. But the court then has declared non-discrimination to have jus cogens status in the region through its advisory opinion, and it's developed substantial jurisprudence tackling structural violence and discrimination, inequality, and exclusion. And the cases that I'm sure you're all familiar with range from the recognition of the right to access to land for Indigenous people, to protection of minorities and children, disabled, the elderly, the LGBT, access to HIV medication, the elimination of poverty, and the protection of refugees. So Judge Farrar-McGregor set forth the notion of what he called exceptional due diligence that is due to the vulnerable people, and the phenomenon of intersectional vulnerability, including poverty, marginalization, and exclusion. And this case law is absolutely significant because it's a direct contradiction to Kenneth Boulding's concern that Johann's concept of positive peace is a metaphor not capable of implementation. The court shows it absolutely is very much capable of implementation. So the majority of the court then interprets human rights as interdependent, indivisible, and considers the socioeconomic rights to be justiciable. But Judge Villagrossi disagreed and gave a very clear opinion that he only considered civil and political rights to be justiciable, and was worried that if we expand this line of cases, that you're going to have a flood of cases that are addressing underdevelopment. And Sierra Porto also was worried about the possible negative impact on legitimacy of the court due to the alleged unpredictable nature of second and third generation rights, and the relevance of multidisciplinary actors like sociologists and social workers to address peacemaking. And that's showing that the programmatic aspects of peace go beyond the role of the courts, and those two judges are a bit uncomfortable with that. So the book then, instead of looking at the positive, I chose the negatives. I chose the cases where the states had not complied with the non-repetition orders, because my theory was that I'm going to have a clear understanding of why states are resistant to implementing precisely those orders that would be correcting the violations of equality and non-discrimination. So I found the cases, and I saw that the non-repetition orders were calling for things like returning land to displaced people, to stop the prosecution of Indigenous leaders, to provide food security programs, and so many cases calling for education, calling for training of state officials, police, prosecutors, judges, and border guards to teach them about non-discrimination against these vulnerable groups, against refugees, against Indigenous people, human rights defenders, and racial profiling. So all of these cases then were right on point, giving states instruction that this is how we're going to get peace. We're going to educate the population into lifting people who are in marginalized situations. And these are the cases the states show very little political will to implement, even though when you look at these orders, they shouldn't be that difficult to pursue. So when I spoke to Judge Elizabeth Olio Benito, she indicated that the woman is the heart of peace, and the Inter-American Court of Human Rights protects women and children, hence the court protects peace. And it's notable then that we have this juxtaposition that 32 countries in the region have ratified the Convention on Prevention, Punishment, and Eradication of Violence Against Women. And we have national legislation on domestic violence, economic violence, and sexual violence. But Latin America has the highest rate of sexual violence against women in the world. And so Latin America then has been characterized as having formally feminist states that fail to guarantee a sustainable gendered peace in practice due to the persistent state of impunity regarding gender violence and a chronic lack of transparent institutions protecting women and girls. So I set about trying to define how I would understand a sustainable gendered peace. And then I sort of combined substantive norms, which would be recognition of the equal protection, non-discrimination, dignity, but also recognizing that we absolutely need to embrace programmatic approaches that would address poverty and economic and political exclusion from participation, as well as sexual and reproductive health, but also recognizing that one of the biggest reasons why they don't enjoy peace is because they have no procedures, they have no access to justice, and that so much of the focus is on state responsibility when it's non-state actors that are committing the violence. So I definitely am supportive of programmatic approaches to education as well, agreeing with the court that the non-repetition guarantees in this direction are very, very important. And we see that there is a politicization of women's issues, in part due to concern for the issue of abortion. And this is then defined as an autonomy right. And you had counter movements against abortion from groups that were articulating the right to religion or the right to life. And this became very, very problematic in relation to not just abortion, but all the other cases that the court was looking at that had to do with protection of women and LGBT rights regarding the use of IVF, the right to access pension after the death of a same-sex partner, the right to change one's name according to gender identity, and the right to marry a partner of the same sex. And so the majority, of course, confirmed the fundamental nature of non-discrimination and equality to address all, that if you were to exclude LGBT persons from non-discrimination, that in itself would be a violation. But again, Judge Villogrossi issued dissents which countered that issues pertaining family rights should be determined at the national level. And he echoed almost verbatim the briefs that were presented to the court by the conservative NGOs. So you had a mirror of the social polarization that is can be viewed in the briefs presented to the court. And the court's majority jurisprudence then goes ahead and articulates a very clear due diligence obligation of states to pursue structural reforms and education of state actors to guarantee women access to justice and protect them against violence. But I looked at, again, I did the negative study of looking at the non-repetition orders which had not been implemented in relation to gender. And if we look at them, again, it's talking about training. When you have a case involving a refugee woman who is sterilized against her will, the court says that the doctors, the medical students have to be taught on gender-based discrimination and stereotyping. Regarding a homosexual woman who lost her children, the court wants the judges to learn about non-discrimination. And for Mexico, again and again and again, in so many cases, the court keeps reiterating that we want due diligence obligation to train the police, the prosecutor, the judges, the military, and the public officials on gender discrimination and stereotyping. And all of these orders remain without compliance. And there we understand why positive peace is difficult to implement. So what I conclude with is that we remain with this challenge, just like Roosevelt said very clearly in the beginning, that we have to renounce violence and we have to embrace peace. I think we're at that moment again, but I think we have to embrace positive peace because we absolutely need strategies to reduce the ingrained inequality that has not been resolved by democracy or the fact that we're not going to war against each other. I'm concerned about the securitization of all our societies and militarization of all our societies, using the excuses of the increased state of crime and the amount of control that narco-traffickers and other groups have, and the exclusion of the youth, the human rights defenders, and indigenous people. The social spaces are closing for them. They are not able to express themselves because they get hauled in and called terrorists or subversives, and they're put in jail. So the court should continue with the provisional orders and cooperate, as Jorge Contessa says, with civil society to follow up to ensure that there is compliance with many of these orders. Because unless we rebrand these reparation orders as positive peace measures, this is something that maybe can help lift the political will of the states, that they will understand that maybe we will have a reduction in violence if they actually implement these measures. So thank you very much.
Thank you very much. It was very interesting. We will now hear from Jorge, but I wanted to remind the audience that if you have any questions, please feel free to post them in the Q&A function, and we will address them at the end of Jorge's presentation. Thank you very much. Jorge, the floor is yours.
Let's see, I need to stop my share.
Okay. Thank you, Laura. And of course, thank you to Cecilia for, first of all, for writing this fascinating book. I had the privilege to read it about a year ago when it was just before going to the publisher. And I'm going to say just a few things that I noticed back then when I had my first encounter with the manuscript, which is, this is a fantastic piece of work for everyone who is interested in not just Latin American human rights law or inter-American human rights law, but Latin American constitutional law as well. As Cecilia says at the very beginning of the book, her effort to bridge human rights law with constitutional law, with scholarship on peace, is, I believe, the main contribution, the one distinctive contribution that the book makes. We, and I myself, I think I'm part of this group of scholars who try to think about both human rights issues and constitutional law in the context of Latin American politics, where all Latin American constitutions have very strong norms on their commitment to international law in general and to international human rights law in particular. And so I just find myself in good company with a number of colleagues who think about these issues through the lens of both international human rights law and constitutional law, comparative constitutional law, if you will. But here, what we have is really this distinctive approach which uses the framework of peace, both in a positive and negative aspect, as Cecilia has already explained in the book. Throughout the book, we see this contrast between negative and positive peace or approaches to peace. But to me, the one significant, the key contribution, as I say, is the effort, which I think Cecilia largely succeeds in weaving together these different areas, right? Particularly the way in which scholarship on peace and international peace has somehow been neglected by those of us who work on international law, international human rights law, and constitutional law. So I have to say that one huge contribution Cecilia is that Cecilia makes here is to be applauded. The way in which the book calls our attention to that area of international law. And it's under this slide that I'd like to offer a few comments as to this project and what we may see, not necessarily in Cecilia's work, but other scholars' work in looking into the future, how these different approaches could actually work together. Because Cecilia starts with the idea that there's evidence, as she says at the very introduction, there's, quote, evidence of an evolving customary law of peace, right? That's the way I see the main thesis. And if that's the thesis, whereas there is this construction, this evolving norm of customary law of peace in the specific context of Latin America, then my thinking is that we should evaluate not just the book, but particularly the work of the Inter-American Court of Human Rights through that particular lens. Right? If there is such evolving norm, if there is such evolving customary law of peace, the question then, which Cecilia undertakes in her book, is what is the Inter-American Court of Human Rights doing? How is the Inter-American Court of Human Rights doing whatever it's doing to promote and solidify that evolving law of peace, the customary law of peace. And so here's where I think the book does something that I found particularly interesting, which is it visits and revisits many of the most prominent cases, and particularly many of the most recent cases. And because of the framework of both negative, but certainly positive peace, it evaluates and invites the reader to think about those recent cases, that recent trend of case law, I'm sorry, and to ask oneself whether or not those cases and this jurisprudence by the Inter-American Court of Human Rights could actually promote and solidify the evolving customary law of peace. And so my sense is that it's easier to do that with the most established jurisprudence by the Inter-American Court of Human Rights on what Cecilia calls negative peace, right? So when we think about, for example, cases on forced disappearances or extrajudicial killings, many of the human rights violations that were perpetrated sort of at the beginning of the Inter-American Court of Human Rights, of the Inter-American Human Rights regime, right? 30 years ago, the court was handling those type of cases. And so that jurisprudence is, in my view, particularly solid. There's the 2001 Barrios Altos and La Cantuta cases against Peru, where the court really sets its voice as this legal and moral watchtower of Latin American human rights. And so here I'm building on my own work, where I question whether or not in the present context, in the present social, political, certainly legal context, the tools that the Inter-American Court uses should be the same when the social landscape and the political landscape and the legal landscape has so dramatically changed in Latin America. So we go from those authoritarian regimes committing these serious and gross human rights violations to non-authoritarian regimes, which of course have significant problems, but for the most part, we're looking at democracies where there are, again, for the most part, fair and free elections, and with cases that deal with different aspects of human rights protections. And here's where Cecilia's approach, which I think is very smart in the context, in the sense of positive peace, really takes hold. The question being, in the present context, where we have most Latin American states with free and fair elections, where we see violations of human rights that are not necessarily connected to, again, authoritarian regimes, but what she calls and other scholars call structural inequality, with intrastate situations of violence, criminalization, the lack of due diligence, and once again, the quest for social justice. My concern is whether or not international law is the best vehicle to channel those demands. And here, Cecilia explores the recent case law on social rights, for example. So just to focus on this positive peace aspect and link this to one of the most, I would say, serious problems in Latin America, which is inequality, right? As the book explains, and many other commentators have explained. And so we look at those cases on social rights and social rights protections. And Cecilia, and she just mentioned some of those cases and the dissent, for example, by some judges, Villogrossi and Sierra Porto in particular. And so my question here, my concern is whether or not the goal of achieving peace by, among other vehicles, securing and protecting social rights is something that we should expect from an international human rights regime, not just the court, but in general the regime. And so that's a conceptual question, and we should talk about it. And then a more specific question connected to this one is, in the specific context of the Inter-American human rights regime, is the Inter-American human rights regime, and more specifically, the Inter-American Court of Human Rights, equipped with the necessary tools to do this, to deliver social justice by, for example, protecting, recognizing as justiciable social rights? And so one step further down is, okay, let's look at the legal materials here, which Cecilia's book does. What we see is the American Convention, which not only is silent about peace, as she correctly says, right, or the American Declaration, but is generally silent about social rights protections. There's only one provision, Article 26. And here the key, the sort of jurisprudential key, I think is critical, and I would love to hear from Cecilia and others what your thoughts are. Because what we see here is the Inter-American Court understanding that there's a significant social problem in Latin America, which is inequality. We can all agree on that. And then finding that through Article 26, even though Article 26 is really shy, and the additional protocol of San Salvador, which establishes only two very specific ways in which one can make social rights justiciable, the Inter-American Court, however, the majority of the court, understands that we have reached a point in which anyone can claim any social right as justiciable. The goal being positive peace, the goal being the fight against inequality, the problem being international law overstepping on domestic constitutional law. And why I think this book is important is because it shows us some of the developments at the level of domestic law. And so my question here is, again, it's a genuine question. I have my own thoughts, but I'd love to hear from Cecilia, is whether or not we are expecting too much from an Inter-American Court of Human Rights, from an Inter-American Human Rights Tribunal, to do both, to contribute to international peace, which is one of the main goals of the whole international legal regime, and at the same time to contribute to social justice at the domestic level. If one were to think about the relationship, as Cecilia invites us to do, between human rights law, constitutional law, and peace, what I would say, and this would be my final remarks, is if there's really an evolving customary law of peace, then one way to assess the success of that project, I think, is by looking at, for example, the International Court of Justice, and whether or not that court converses with the Inter-American Court of Human Rights, whether or not the ICJ understands that concern, as the ICJ should be, right, with international peace and security, that human rights law can provide insights and can feed the construction of this customary law. My sense is that so far the ICJ has been rather reluctant to embracing some of the most progressive doctrines that the Inter-American Court of Human Rights has articulated. Cecilia mentions in her presentation the advisory opinion number 18, where the Inter-American Court of Human Rights articulates the notion that the principle of non-discrimination is a jus cogens norm, right, under international law, and notwithstanding having the key author of that idea, Antonio Cansado Trindade, on the ICJ has not taken that step, and there's no indication that it will. So that's one type of question, one kind of avenue of question, which is, can the Inter-American Court of Human Rights in particular, or I would say in general, any international human rights tribunal, contribute to the construction of a customary law of peace, not just in the context of Latin American politics and human rights, but in general. Why? Because international peace and security is a general universal goal of the international legal regime. And second, can the Inter-American Court of Human Rights, by adopting these more aggressive and progressive views on social justice, i.e. the ways in which now it is recognizing social rights, contribute to peace at the domestic level? And that to me is really an open question, because what one sees is the potential of what Sierra Porto says in his dissent, the potential, the peril in my views as well, that it could damage the court's legitimacy by taking these steps that are not found in the text, that are not found in the travaux préparatoires of the American Convention, and that are found at the domestic level. And so my sense is that we see a court that is concerned correctly with social justice, but unconcerned, incorrectly in my view, with the doctrinal tools that it uses to bring about social change. Thank you so much for allowing me to give these remarks, Cecilia. Thank you so much for sharing your book with us. And thank you so much for making this big contribution to the scholarship on human rights, constitutional law, and peace.
Yes, I completely agree. And thank you, Jorge, as well for your comments. I don't know if Cecilia would like to say anything in reply to your comments, or if we can address the question that was posted in the Q&A function. Maybe I can read it, and then Cecilia, you can answer the question and reply at the same time. So Sarah Thompson is asking if the lack of compliance related to the training to support positive peace is a problem, and what you would recommend to help foster that compliance, and especially what sorts of mechanisms you could recommend to address this.
Thank you. Okay, so first, thank you, Jorge, for your amazing comments. Very reflective and deep, and so important. So the question also very to the point and very relevant, and the key to everything. They're related, so I'll answer them together. Peace has to be constructed from the bottom up. It cannot come top down. And if it's one thing we've learned in human rights and international law, that when we try to approach things top down, it has a huge chance of being misapplied, misinterpreted, and not achieving what we actually believed. So I think that when we look at the reparation orders that are going to the base level of society and asking for training of the actual actors on the ground, the police and the judges, the border guards, the medical profession, they are indicating that we need these new narratives of emancipation, that they have to come from the bottom up. Otherwise, there will be no emancipation. And this is why there's a resistance to compliance. But the court has created a unit on compliance, and it really has done a lot in terms of trying to send people out to talk to the local actors and to create tables to have dialogues on what the compliance problem is, to try and work it out. And many of these groups, when you look at them, if they're professional groups, it is possible then to contact the medical association, the police association, the judges association, to get involved with those networks that are at the local level, to understand that it's not just talking about implementing orders in the old-fashioned way, where just the one ministry, be it the Ministry of Foreign Affairs or the Ministry of Justice itself, would be involved, that we actually have to go at a lower level and a more broad level in terms of addressing compliance and getting that narrative of peace going. And when we look at the groups that are marginalized, I was so surprised to see how many young people are politically engaged in Colombia, for example, that have huge aspirations to enjoy peace in their country. They are young, and they feel that the regular channels of political participation are close to them. So I was talking to them and I said, why don't you create alternative channels through social media, and create alternative, like people's courts and places where you can address the types of abuses that you're seeing in order to engage. And I was concerned because they showed a great degree of cynicism at a very young age, at 18 or 20, feeling that there was no hope. And I can't believe that we have reached a point in our region where the youth actually have no aspirations anymore. So that's why I say we are at one of those turning points in a region that we have to make a grand gesture. And the court, as an institution that represents resolution of conflicts in a peaceful way, its very existence of inviting states to bring their conflicts to a forum where it will be decided in a nonviolent way, is an important actor in trying to emphasize mechanisms for resolution of disputes that will not involve violence. And so I think they're a natural actor. But when I spoke to the lawyers about being more open about the use of peace, they were very nervous because of this trend of oppressive peace, that peace can be used in the name of security, in the name of counterterrorism, and they're saying they're doing a peace action, but they're putting people in jail. So the court, because it's concerned with legitimacy, is very hesitant about engaging in norm evolution the way it did when it created the prohibition of enforced disappearance, which also is not listed in the American Convention, or the right to truth, and many other normative terms that they've come up with. I'm not sure whether they're going to be comfortable leading normatively, even though you say that it should be possible for them. Just like the ICJ does refer to discrimination in many cases, but you saw in the latest case having to do with discrimination on the basis of nationality, they took a very narrow view. So I think we're going to see a degree of caution on the part of the court in moving in a direction that may be seen as destabilizing in an age where societies and states are worried about instability.
Thank you very much. I think we could discuss this for much longer, but we are nearing the end of our time. And actually, we will have the annual business meeting of the Latin America Interest Group of ACE right after this. So I will post the link because it will be in another Zoom conference. So I will post the link for the business meeting in the chat so that everyone who would like to join can join. And I will let Jorge give the closing remarks, maybe in reply to Cecilia's latest comment.
Thank you, Laura.
Thank you very much.
No, thank you. If there are any other questions that people would like to ask, I would rather have them take the floor. And maybe Cecilia, if you want to respond to any of the comments that I made. As Laura says, we could talk about this and about the book and these themes for many hours, as I'm sure everyone knows. But I'd rather have you take the floor, Cecilia. If you have any other remarks that you'd like to.
No, well, I thank you for being so generous, because I told you that I wrote the book during COVID, and I lost my cousin who has the same name as you. So he was a doctor in Mendoza, and I also got COVID while I was writing the book. So there were a lot of challenges. But when I think about the possibility of improving the characterization of Latin America as a region, of really taking a pride in our legacy of the values that we set forth when we see war returning to Europe again. I think that this is an opportunity that we really can present the world with an alternative vision, and we can lead. And I think the court can lead with its case law, and I think societies can lead by committing to positive peace as the new rallying cry for the region. So that's my aspiration.
That's such a positive way to end the conversation. It's just particularly in the context of everything that is happening right now in the world. And I completely agree with you that it's not just interesting from an academic perspective, but potentially from a political perspective, important to see where efforts to achieve peace have successfully been made. And Latin America is a region that has a lot to offer. Just like we have so many problems, at the same time, we've gone through bloody dictatorships, authoritarian regimes, 50-year civil wars, and being able to use the law to channel those social conflicts. So once again, thank you, Cecilia, for your talk and for writing this wonderfully fascinating book.